Hi, everyone. Thank you for joining us today for Constangy's webinar, Workplace Investigations 301, Privilege Determinations and Reporting, Getting It Right. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters may not be able to address all of your questions during this session, but they will follow up with you offline after the webinar. This program is approved for Sherman HRCI credits. We will be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we'll also be sending out a copy of the slide deck along with a recording of today's session. And since this is part 3 in our workplace investigation series, the follow-up email will include links to the first 2 sessions in case you missed them. I'm now going to turn it over to today's presenters, Rayner Mangum, Darrick McDuffie, and Sasha Thaler.
Thanks so much, and thanks everyone for joining us this afternoon. My name is Sasha Thaler. I am a partner in Constangy's Boston office. I am a co-chair of our workplace investigations practice group along with Taryn Greenwich, and I generally have a mixed practice that includes both advice and counseling and litigation, as well as handling investigations for employers of all kinds, both private companies and as well as universities, and including Title IX related investigations. And I'll hand it over to my colleague Darrick to introduce himself.
Hello, everyone. My name is Darrick McDuffie. I am the managing partner of our firm's Atlanta office and co-chair of our Trade Secrets Unfair Competition Practice Group. And I have a busy practice of workplace investigations, as well as restrictive covenants litigation. And I focus on discrimination lawsuits of all types in state and federal court throughout the nation. And I will hand it over to Rayner next.
Hi, everyone. I'm Rayner Mangum. I'm an attorney in the firm's Denver office. I have a mix of litigation matters and advice and counsel, and of course, I'm also a member of the firm's workplace investigations practice group.
And so as we start off our webinar today, we just wanted to give you a brief overview of where we wanted to go. As you heard at the initial announcement, this is the third in our series. So this is intended to be a deeper dive into a few of the more thorny and potentially difficult issues that you may face when you are either conducting an investigation or helping to shepherd one forward. So first and foremost, of course, are issues around privilege. And we'll take a deeper dive than we have in prior webinars in the earlier installments of this webinar into privilege issues. We also want to talk about considerations for reaching a determination as an investigator. That is generally why you're engaged to investigate, is to help the business understand not only what happened, but whether something did or didn't happen and what it may mean for the business. And finally, we want to talk about documenting your conclusions and the variety of ways in which you can get to a point where you've concluded and you have reported out the results of your investigation. So we'll start off with a discussion of privilege, and Rayner, take it away.
Sure. So we're going to talk today about the attorney-client privilege and the work product doctrine in workplace investigations. With respect to privilege considerations, the first step before beginning an investigation is to make sure that you know the purpose and your goals. Investigations can be done for several purposes, including legal decision-making, compliance with policy, preparing for litigation, and making business decisions. Only some of these purposes would be privileged. And given that you will have to be proactive about establishing and maintaining privilege throughout the investigation, it's important to decide this at the outset. We have 3 main types of investigations. First, we have privileged investigations, and we'll cover the elements of a privileged investigation during this presentation, but generally speaking, these investigations will be done to help the company make a legal decision or prepare for possible litigation. Then we have non-privileged investigations. These would be done for a different purpose, such as purely for fact-finding. Where this is the case, you need to be aware that documents and communications pertaining to the investigation will be discoverable in any subsequent litigation. And then finally, we have dual-track investigations. And this would be a situation where there are two investigations occurring simultaneously, with a non-privileged investigation going on purely for fact-finding, and a second shadow investigation being conducted by someone else under privilege. With respect to workplace investigations, we have two main privileges or doctrines. We have the attorney-client privilege and the work product doctrine. Looking first at the attorney-client privilege, this privilege applies to confidential communications between a client and legal advisor for the purpose of seeking or providing legal advice. The purpose of the privilege is to allow full disclosure between attorneys and their clients. And the privilege is a two-way street. It protects communications going from the attorney to the client and from the client to the attorney. So the first element of the attorney-client privilege is confidential communications. Under the confidential portion of this element, you'll want to make sure to limit the involvement of non-attorneys to only individuals who need to be involved in order to further the investigation. Limit the circulation of privileged communications internally to only those who need to know. Disclosure of communications to individuals who do not need to know or who do not need to be involved in order to further the investigation will undercut a claim that the communications were in fact confidential. Next, you'll want to explain to witnesses the need to avoid disclosing the substance of the interview to others. And relatedly, you want to make sure to give and document having given witnesses an upjohn warning to avoid the possible misimpression that counsel represents the witness rather than the company. In the upjohn warning, be sure to note that the interviewer represents only the company, not the witness, that the communications will be protected by the attorney-client privilege, that the witness should keep the conversation confidential, and that the privilege belongs to the company, which can choose to waive the privilege and disclose information relating to the investigation at any time. Lastly, you'll want to label communications as confidential and attorney-client privileged. But note that while this is indeed a helpful step to take, labeling a document as attorney-client privileged is not alone dispositive. All of the substantive elements of the privilege must still be met in order for the privilege to apply. And then now looking at the communications portion of this element, it's important to remember that the privilege protects only communications and does not protect the underlying facts. So the second element of the attorney-client privilege is that the communication must be between the client and the client's legal advisor. Here, communications between counsel for the company and company employees will generally be considered privileged so long as the communications are for the purpose of seeking or providing legal advice and they pertain to matters within the scope of the employee's duties. Whether the privilege applies to communications with former employees is a murkier issue, and it often depends upon the particular jurisdiction that you're in. In some jurisdictions, communications with former employees may be privileged if the communications were had at the request of management and pertain to matters that were within the scope of the former employee's duties. But in other jurisdictions, they reject the assertion of the privilege entirely with respect to communications with former employees. So it's important to check the law of the jurisdiction that you're in. And then under the final element of the attorney-client privilege, the communications must have been for the purpose of seeking or providing legal advice. Communications that are being done for other purposes, such as to gather facts or make a business decision, will generally not be privileged. You'll want to draft an investigation plan at the outset of the investigation, stating something to the effect of that the investigation's purpose is to obtain the facts necessary to provide legal advice to the company. And then you'll also want to carefully label and preface communications to make the privilege purpose clear. Here you should expressly state in written communications that the purpose of the communication is to seek or provide legal advice. So for example, in the first line of a body of an email, you could write something to the effect of, I am writing to provide legal advice regarding X topic, or I'm writing to ask for legal advice on X issue. So best practices for establishing and maintaining the attorney-client privilege. You'll want to prepare an engagement memo or an investigation plan, which states that the purpose of the investigation is to provide legal advice. You'll want to carefully label privileged communications, give witnesses upjohn warnings, limit the disclosure of privileged communications to only those who need to know, and lastly, avoid combining business and legal advice. And this is particularly true for in-house counsel who often wear both legal and business hats. Make sure to avoid mixing business and legal advice in your communications. Address business advice in a separate email. And if business and legal advice necessarily overlap, expressly state that the primary purpose of the communication is still to provide legal advice. Next, we're going to look at waiver. And here, even where all of the requirements for the privilege have been met, the privilege can still be waived. So for example, we could have waiver through disclosure of information to individuals who do not need to know. And this would include disclosures to the public generally, such as in a corporate filing. We could have waiver through partial disclosures during litigation. For example, if you were to disclose the investigation report or fail to object if the investigator were deposed and were to be questioned about privileged communications. And it's very difficult to cherry pick and disclose only some privileged information pertaining to the investigation without waiving the privilege entirely. So you'll want to decide at the outset whether you anticipate needing to do something like disclosing the investigation report, because if you do so, you are likely waiving the privilege as to the entire investigation. And then lastly, we could have waiver through the assertion of particular defenses during litigation, such as the Farragher-Ellerth defense. And this is an affirmative defense, which does waive the privilege. It generally pertains to claims of sexual or racial harassment in which the company argues that it exercised reasonable care to investigate the allegedly harassing conduct and that it took prompt remedial measures. So the company can't withhold otherwise privileged investigation-related documents if it relies upon this defense. Essentially, by placing the investigation itself at issue in the litigation, the company can no longer rely upon privilege and hold back documents and communications pertaining to the investigation. And then we're going to talk about considerations for non-privileged investigations. So here, if the investigation is going to be non-privileged, you want to make sure that the investigator's report is limited to the facts and does not contain any legal advice, that the investigator avoids including any privileged information in the report, and that the investigator is not involved in any privileged communications regarding the investigation. And then also be aware that you may be asked for legal advice, even if you are in solely a fact-finding role. And here, Darrick, I think you had some thoughts to add on this point.
Thanks, Rayner. Yes, in a situation where you are purely in a fact-finding role, you still may be asked by the client or whomever is directing the investigation to provide legal advice. And this is where communication is key, to go back to the steps that Rayner just explained to explain why it's important as a fact finder to limit your involvement to only investigating and reporting on the facts and not providing legal advice, because you will potentially end up in a situation where you could waive privilege and you wouldn't want to be in that situation. So that is the concern that you want to be aware of when you're asked to provide legal advice when you're solely a fact finder. And I'll turn it back over to you, Rayner.
Yeah, thanks, Darrick. And just some final points here. With respect to the investigator in a fact-finding investigation, you'll want to have the investigator report the facts, but then excuse the investigator from any subsequent privileged communications. And just always be aware that the investigator may be deposed and all of their notes may be disclosed. So now we're going to jump to the work product doctrine. This doctrine protects documents and tangible things prepared in anticipation of litigation by or at the direction of counsel. And the work product doctrine is designed to protect an attorney's mental impressions, thoughts, and opinions that are developed in anticipation of litigation. The work product doctrine is not as strong as the attorney-client privilege, but it is broader in scope. Here, you'll want to note that the work product doctrine can be overcome if the other side shows that the requested materials are otherwise discoverable, that there's a substantial need for the materials, and that the other side can't, without undue hardship, obtain the requested materials by other means. If the court orders discovery of the materials that would otherwise be protected by the work product doctrine, the court must still protect against disclosure of the mental impressions, opinions, and legal theories of a party's attorney concerning the litigation. So for the work product doctrine, the key here is in anticipation of litigation. So reports and materials that are prepared in the ordinary course of business would not be protected by the work product doctrine. And the in anticipation of litigation is a murky standard. So you'll want to check the law of the jurisdiction that you're in. In many jurisdictions, a lawsuit or claim does not yet need to have been filed, but there still must be a reasonable likelihood of litigation. So looking here at best practices under the work product doctrine, you'll want to prepare an investigation memo or plan at the outset of the investigation, which documents a concern about potential litigation, as well as the facts that make litigation reasonably likely. And then expressly state in the investigation report that the report contains the attorney's mental impressions, thoughts, and opinions. And then lastly, be sure to put in place a litigation hold if you plan to assert this doctrine. You're going to have a hard time defending the lack of a litigation hold if you plan to assert that the company did in fact anticipate litigation. And so now I'm going to turn it over to Darrick to talk about best practices for reaching determinations.
Thank you, Rayner. So for best practices for reaching determinations, we begin with the understanding that reaching determinations is a delicate balancing act. And why is that? A good investigator will start thinking about possible determinations as soon as he or she is called on to conduct an investigation and is told about the alleged conduct. The reason is because the investigation has to be designed and implemented in a way that allows for the investigator to reach determinations on all the issues under investigation. Here's the question. What do I need to do to ensure I have all the information necessary to answer these issues under investigation? That is the task. At the same time, it is also critically important that an investigator not prejudge the facts. Now, this is not an aspiration. This is a necessity. Make sure there is no prejudgment. To do this, it can be helpful to communicate both during meetings with the investigator and the client contact who is managing the investigation and internal meetings within the investigative team itself to make sure that everybody is on the same page to avoid prejudging the facts. Also, it's often helpful to let the target or the potential target of the investigation know that the investigators have not prejudged the facts. Of course, this is a matter of fairness, but it's also a matter of good practice because a witness who is guarded against the process because they believe the facts have been prejudged will be a more difficult witness to deal with than a witness who is open to the process because the witness has been assured that the facts have not been prejudged. So the takeaway is be careful that no decisions in the investigation are tainted by anyone prejudging the facts. And this goes for the documentation that needs to be requested in connection with the investigation, the selection and order of witnesses and how those interviews are conducted, and the questions that are asked during the interviews themselves. Now we'll move on to framing the issues and the determination of key issues. To reach good conclusions, first and foremost, the issues must be framed appropriately. If not, you'll notice at some point in the investigation, there will be questions that should have been asked but haven't been asked. There will be documents that you will think are important but haven't been requested. Now, in fairness, there are situations where the issues during the investigation will need to be reframed. That's something that happens. So a good investigation will need to be flexible and follow the evidence where it leads. And sometimes that new evidence, when it's uncovered, can require the issues to be reframed. Again, the key here is effective communication, not only within the investigative team, but also with the contact who is managing the investigation. So if there comes a time when the issues need to be reframed, a good investigation will be able to explain why that is happening based on the new evidence that has been uncovered during the investigation. Next, in terms of reaching the determination, there are two lenses through which investigators are viewing the evidence. There is the client's workplace policies on the one hand, and there's the law on the other hand. The focus you will hear later, and I won't give too many spoilers, will be on the workplace policy. My view is that it is good for an investigator to be familiar with the litigation process because lessons learned in litigation can help guide how to structure workplace investigations. What I mean is, it's not just enough to be familiar with the law. A good investigator doesn't have to be a lawyer, but a good investigator will have been in the trenches, will have participated in litigation, will understand the pitfalls that can happen in litigation because those are issues that will need to be at the forefront of your thinking as you are making decisions about your investigation. Another issue that can arise is the need for interim determinations. And I'll provide an example to explain what this means. If you have an investigation in which there's an allegation of an improper relationship between an employee and one of the company's subcontractors, an interim question may be whether there is a consensual romantic relationship between these individuals. If you can confirm this, the next question may be, does that relationship nonetheless violate workplace policies? If you have a dispute regarding the nature of the relationship, then all bets are off at that point. The investigation can take a totally different direction, and certainly issues will arise, such as whether there are allegations of sexual harassment or improper conduct between the individuals from one to the other or vice versa. Another issue that arises in investigations is whether there have been prior investigations. Generally, I don't advise investigating investigations. It doesn't sound good. It also is not a good process. But generally speaking, if there were prior investigations, an investigator should understand the facts that were involved, should understand the issues that were investigated, and should understand the determinations that were made, because it will be helpful in making sure that the investigator isn't later susceptible to allegations or claims that things that should have been investigated weren't investigated. And certainly the investigator should have known because there were prior investigations into those matters. As you can see, there's a theme here. Communication is key. I think we've all seen on television and popular movies, there's this common trope of a very skilled investigator, perhaps a private investigator, who is a terrible communicator. I'm here to tell you that's not how it works in the real world. A good investigator doesn't have to be a classical extrovert, but a good investigator will be a good communicator. And what does that mean in practice? Everything about an investigator's communication will be important in the investigation. The mode of communication. Should you use an email? Should you pick up the telephone? The style of the communication. Are you being inquisitive? Is it matter of fact? The tone of the communication. Are you expressing understanding? Are you expressing confusion or lack of understanding? The volume of the communication. Are you calm? Are you being assertive? And the timing and frequency of the communication, especially, again, when it comes to meetings with the contact who is overseeing the investigation. Of course, these are just some examples. The idea is at every step when making decisions, be very thoughtful about communication during the investigation. Now, for those on the call who happen to be clients, I'll let you know that there are, generally speaking, two rules that I think all clients will agree should be adhered to in all investigations. One, stay in communication to avoid surprises regarding the scope of the investigation or its determinations. Nothing is worse than surprises on either of those fronts. And two, provide practical, and I stress practical legal advice if the investigation is in anticipation of litigation. Next, we have the nuts and bolts that go into reaching determinations. We have things such as, who is the complainant? Is it possible there are more complainants we don't currently know about? Who is the accused wrongdoer, or is the wrongdoing more of a systemic issue? And who are the potential witnesses, or might there be a need to have conversations with individuals to uncover additional witnesses? These are all questions that need to be addressed and very carefully decided. Interviewing former employees presents its own set of problems and frankly could be its own webinar, but suffice it to say, tread carefully when deciding whether to interview former employees, unless there's already a lawsuit, in which case you should want to interview everyone. When interviewing a former employee, even if there's a proper basis to assert attorney-client privilege, my rule of thumb is to proceed with the assumption that everything you say to this former employee can be spoon-fed to a potential plaintiff or a potential plaintiff's attorney. That's really the reality we're facing when interviewing a former employee because we don't have control over them. And as a reminder, as Rayner explained earlier, whether privilege applies to former employees is, I think, murky, as Rayner put it succinctly, because it can vary state to state. So keep that in mind. As for documents, most investigators have a good sense of the documents needed generally. Then the question becomes, what particular circumstances require collecting additional documents beyond the common things such as the complaint itself, that's the basis for the investigation, personnel records of the individuals involved in the investigation, etc. One source of documents that should not be overlooked is simply asking individuals who are interviewed whether they are in possession of relevant documents to the investigation. Also, for interviews themselves, there are a number of questions. Are there reasons to interview witnesses in a particular order? Are there issues in the schedules of witnesses? Do you have witnesses who are on vacation? Might a witness be on a leave of absence? Perhaps a witness is on a leave of absence in connection with things related to the investigation itself. Are in-person interviews preferable over virtual interviews? These can all be questions that need to be considered when making decisions about how to proceed with interviews. There could also be language barriers that could require the use of an interpreter. So the idea is there is no one-size-fits-all solution. Each investigation will have its own needs, and these questions need to be addressed on a case-by-case basis. Finally, again, the theme here, communication is key. Please have periodic meetings between the investigation team and the contact who is managing the investigation. And those periodic meetings will cover not only what is being learned during the investigation, but in terms of the process, whether what is being learned requires any adjustments to the investigation itself. The next issue is the burden of proof, or the standard that is going to apply to the facts as learned during the investigation. More likely than not, this is the typical standard used, but what does it mean? In a situation where you have a yes or no question, what it means is you weigh all the evidence, and based on that evidence, you determine whether it's more likely than not that the answer to the question is yes, or is it more likely than not that the answer to the question is no. Saying it sounds simple, but the key in the process is weighing all the evidence and being aware of how that evidence connects to the issues that you are investigating. You have to literally connect the dots between the evidence and the determination that you're reaching. It's also important to understand that this is not the only standard, and this is not the only way you can communicate about determinations that flow from an investigation. There are questions such as, is there something that's conceivable? Perhaps something that's inconceivable? Based on the evidence. Again, it has to be based on the evidence. Is there something very likely or most likely based on the evidence? There is no science to any of this, but the determinations have to make sense based on the evidence and be described in a manner that accounts for the level of certainty and uncertainty that you're left with at the end of the investigation. Now, for those of us on the call who are investigators, here's the part that keeps us up at night. The things we ponder on that long ride or that flight home after a grueling day or grueling days of investigations and interviews. What to make of everything learned during the investigation. Fortunately, there are tools we use as investigators. First, admissions and denials, those are easy, but what about beyond that? We examine the credibility of witnesses based on numerous factors. We determine whether evidence has been corroborated by independent sources. There can also be written records or documentation of events that either support or undermine possible determinations. And last but not least, good investigators don't ignore logic and common sense. Simply because you are investigating workplace issues doesn't mean that you have to check your common sense and logic at the door. So do remember that. So as you can see from the title of this slide, yes, it is possible that not every question can be answered, even by my esteemed colleagues, Rayner and Sasha. But it should be the rare exception that issues in an investigation are not answered. And even if there are particular questions that are unanswerable, I would challenge anyone to describe any investigation to me in which no important determinations can be made. As a good investigator, you should answer those questions, even when the ultimate questions might end up being a he said, she said, and can't be answered in the end. So finally, what are some of the important questions that you might answer in addition to or in lieu of ultimate issues that are under investigation? Has office morale changed because of any issues under investigation? Are employees experiencing the office culture in the way the company intended it to be experienced, or is there a disconnect? Are there too many employees reporting similar experiences for it to be considered a coincidence. I, for one, when I'm wearing my investigator's cap, I don't like coincidences. So there's probably a determination that needs to be communicated in those instances, such as, for example, if 18 out of 20 employees interviewed expressed similar concerns about X, Y, and Z, there's something important there that needs to be reported, even if that doesn't lead to an ultimate determination. Do employees have possible action items that they'd like to share with the company to address their concerns? If these are offered during interviews, it's at least worth a conversation to determine if it's helpful to report those employees possible action items to address their concerns. And finally, were there any impediments to the investigation? Was perhaps a witness unavailable for some reason that could not be resolved? If something of this nature impacted the investigation, it's probably worth explaining the ways in which it either impacted or potentially could have impacted any determination reached or not reached during the investigation. So with that, I'll turn it over to Sasha to discuss best practices for documenting conclusions.
Thanks so much, Darrick. So as we talk about this additional piece, right? This is building on the ideas that Rayner and Darrick have put forward in terms of you've done all this work preparing how to set out your investigation, how to go through the process of the investigation, getting to a determination, and then what? Right. And so first I want to say a lot of what I'll talk about will be particularly relevant for a detailed written report, but that's certainly not the only option. You could have no written report. It may be the case that an oral report is the most appropriate way of conveying your determinations. Or you may have occasion to be writing something more of a summary report. Either because that's the best way to convey the information, or because there may be two reports, one that is, for example, provided back to the complainant and respondent to show that the investigation was done and what the resolution was, and another that's maintained internally as confidential or for some other reason. And then in terms of deciding how you approach your reporting out, whether it's oral, detailed in writing, etc., some questions to consider, right? So who will be receiving it? Is it, as I said, the parties? Is it the board, etc.? How will it be used for litigation, for complying with your policy, etc.? And then what is your position with respect to privilege, and how might that change in the future? And so, of course, as you can probably hear from what I've said, and certainly building very much on what Darrick has said, these are almost certainly not questions that you as an investigator or you as somebody who's engaging an investigator will be deciding in a vacuum. These are things that should be discussed early and often. And so what might be the reasons that you might, for example, go down the path of having an oral report? Well, one might be if it's an extremely sensitive matter. Maybe it is an investigation of the CEO that's been commenced by the board. Maybe it's something time sensitive, where there just really isn't time to spend a lot of time and energy on writing a detailed report. There has to be some reporting out in advance. And so maybe the oral report is the most appropriate way to handle it. Maybe there's some privilege considerations that need to be taken into account, where the report can be done in a privileged space in a way that the facts determined in the investigation and maybe some of the process of the investigation may not be. If you are looking at the bottom item of these three, if you are in a place where perhaps you are you've engaged in the investigation in order to comply with an internal policy that says you will investigate certain kinds of complaints, the canonical one being, of course, a sexual harassment type complaint, then maybe you need to identify in great detail all the steps you took, because it's not going to be a privileged report. It's rather going to be one that you're going to rely on to mount a defense if there is litigation, right? So you want to show that there was a substantial investigation that was conducted, and you want to have memorialized all the pieces of that investigation. If you maybe had a more limited investigation, whether it's because there's not a policy that requires an investigation to be created or to be engaged in, but you have determined that that's the path forward, or maybe because you have two investigations, one that is the fact-finding investigation, one that is privileged investigation for the purpose of providing legal advice, you may want to have a summary where there's maybe not as much detail and not as much of a long and drawn out discussion of how every fact was resolved, but rather something that just identifies the overall issues, the overall process, the overall determinations reached and reasons why. And of course, you may have a combination of, two or all three of all of these options. I know, Darrick, you and I have had some conversations about, instances in which you may choose to go one way or another. And if you have a word of advice or a particular example of one where, it was very clear to you and the client that, an oral report was not only expeditious, but maybe the best way to move forward. Yeah, if you'd be willing to share that, maybe people would appreciate that as an example.
Absolutely, Sasha, I'd be happy to. One of my recent investigations where it made sense after consulting with our team and the client to report orally instead of in writing was in a situation where the investigation uncovered, let's just say, a few things that were not anticipated at the beginning of the investigation. And so the investigation could not linger because of those issues, because there was a pressing matter that needed to be addressed. And so there needed to be an oral report out on the investigation with the understanding that there may or may not be things that are done down the road, and they may or may not be done by our investigation team, but we couldn't slow down the process because of those unanticipated things, I will say, that arose during the investigation.
Yeah, that sounds about right. And again, touches on your point that you made several times in when you were speaking, which is communication is key. And I'm sure you would have not been able to get to a decision on what to do in that situation without having those communications that you are obviously having.
Absolutely.
So let's say you're going to have a written report, whether it's a summary or a detailed one, more detailed one. There's a number of pieces of information that it is good practice to make sure you have and make sure you've articulated clearly. So certainly who the parties are, and what the policies are, right? So understanding what is the purview or the umbrella under which the investigation was conducted usually requires understanding what the policy was. So being clear on the policy that was being reviewed, having some description, whether it is at a very high summary level or a detailed level of what the process was that was followed, and having, again, a description of the allegations made. The order of some of this may depend on exactly the nature of the report and the nature of the audience to which this report will be provided. But keep in mind that oftentimes this document will need to be looked at and relied on by people, removed both in time and in connection to the investigation itself. And so being very clear about these issues will really be a big help. And then, of course, you want to give the most prominence to the facts that were gathered in the investigation, because those are going to be the foundation for the determinations. And then, as Darrick pointed out, you want to make sure that the determinations that you're reaching are very closely tied to the facts that you've identified, that you've been able to obtain in the investigation. But you also want to make sure that they're equally tied to the policy that was used to conduct the investigation, and particularly to the burden of proof in that policy. There may be reasons also to be very mindful of issues like bias and other things that may be significantly affecting the investigative process that may not be in the form of document X or witness statement Y. And then there can be a question about whether your report should have recommendations for resolving the matter that's been brought forward. And again, that's something that should be discussed between the client and the investigator to make sure everybody's on the same page about whether there will be recommendations. Last thing you want is, as an investigator, to have recommended, a slew of things, and then for whatever reason the client can't implement them, or perhaps something changes and the client had every intention of implementing them, and then it becomes impossible, and all you're left with is this document that suggests that you said they had to do it or they should have done it. That can be a real black eye if the matter becomes a dispute later on. So having said all that, what should a report not do, right? So what you don't want to do is fail to identify what it is that was investigated and why, right? So you want to make sure that you're very clear about what the allegations were that were investigated and what was the framework in which they were investigated, right? So, for example, there may be times where in the course of the investigation, new allegations arise, and they may not be readily within the scope of the investigation. Well, you need to be clear of what you did do, and if you didn't look into something, it's a good idea to have some explanation of why. For example, I recently had something that was more in the sphere of a climate assessment, where I was looking to see kind of how a particular department functioned by speaking to a number of different individuals and getting each of their perspectives. And in the course of that discussion, somebody made an allegation about very specific misconduct by one of the members of that department. So following a thorough discussion with the client, we decided that information would be conveyed to the client, and somebody else would be handling the matter of whether that additional allegation needed to be investigated and how, because it really didn't fit squarely within the scope of my investigation. You also want to make sure that unless there has been very clear communication that this is the purpose of this report, you want to avoid including legal conclusions, right? Again, sometimes an investigation that at the outset may have been privileged ends up having the privilege waived because of an inadvertent disclosure or for intentionally. And so having legal conclusions, again, could really become a problem down the line. Having said that, that isn't to say that there's no universe in which some aspect of the law may not need to fit into the report. So for example, if a policy is similar to something that may be a legal issue as well, such as a non-harassment, non-discrimination policy, and it, for example, contains some terminology that may that case law may shed light on, it may make sense to bring in some legal considerations for the purpose of interpreting the policy and explaining or justifying how it is that your conclusions about whether the conduct violated the policy are logical and reasonable and well supported. You also, again, don't want to reach conclusions without reference to the specific evidence that's been gathered. And again, you want to avoid not reaching a conclusion unless it's truly absolutely unavoidable. And even in that case, consider some of the things that Darrick put forward in terms of, even if there's not a determination about the specific conduct and the specific policy violation, there may be other important information that can be conveyed and determinations that can be made. So a recap of the sections of a report. You know, what is the issue under the investigation? What were you engaged to actually do, right? What policy applies? What were the mechanics of what you did in your investigation? Who did you speak to? If you didn't speak to somebody, why not? What documents were gathered? If documents were requested and they were not available, why not? Maybe there's some other information, videos, regular business records, etc. What were the facts that were gathered from all of these interviews and materials, and then your analysis. And focusing particularly on the facts just for a little bit, I just want to point out that facts come in all shapes and sizes, and not every fact needs to be given the same amount of attention in a report. In general, you want to focus on the facts that are going to be necessary for you to resolve the issue, right? So whether or not the particular misconduct actually occurred. Having said that, for somebody reading a report, it may be important and helpful to have some background facts or some facts described that are not in dispute, but that sort of help frame and set the stage for what the disputed facts are. So be mindful that there may be facts that you can and should present that help the reader of your report or the recipient of your report understand what's going on. And sometimes those facts may be a little bit in dispute or maybe not exactly all aligned. You may not need to reach a determination, right? If somebody says, I entered the room at 8 and somebody else says that person entered the room at 8:30, you may not need to resolve exactly what time the person entered the room if the facts that you actually care about sort of aren't dependent on whether it was 8 or 8:30 because the incident happened at 9, right? You also want to make sure that you're describing the facts that are going to be the basis of your determination. That may not be kind of the actual fact in dispute. So facts around whether witness has been consistent, whether there's corroborating information, whether there's indications of a lack of reliability or of bias, etc. And as you're writing the facts of your report, be mindful that this is, for those of us who are lawyers in the room, it's not a legal brief. You are not, you've not been engaged to argue on behalf of one client or another. And so be mindful to not be argumentative. State the facts as objectively as possible. You do want to be thorough, but only include what is necessary. But having said that, some things may be outside of the specific facts that are necessary for the determination and yet still be necessary for the report. I know one of the things that we were sort of thinking about is what does that exactly look like? And Darrick, you and I had a discussion on that as well. And I wanted to get your thoughts on this piece in particular before I move on.
Happy to do that. So one example would be if you have an unusual situation, such as someone suffering from an unusual medical condition, or someone involved in an unusual activity. It may not be important to the ultimate sort of conclusion that be understood, but it's helpful to the reader and to everyone involved in the investigation to have an understanding of that. So that would be important background information that would go into the report, for example, discussing the prevailing research or literature in a limited fashion relevant to either the medical condition example that I provided or the sort of unusual activity example that I provided. So those would be just a few examples.
Yeah, I totally agree with that. And I think it goes to the broader point of your report needs to be self-sufficient in some ways, right? And so if you're going to reach a determination, you need to be able to tie back on the basis on which that determination was made. And sometimes that will involve extreme sort of facts that were gathered or available to the investigator, not from direct witness interviews. And on that same sort of note, I do also want to note that, again, this is not an argumentative exercise. It is an exercise in setting out what you learned and then the basis on which you reached a determination. And so be sure that if there is exculpatory evidence, that is included as well, not only the evidence that confirms your determination, but if there is evidence that might suggest that a different determination, arguable that a different determination could have been made, that should be incorporated and then addressed as necessary. And so, of course, the biggest decision we all have to make as investigators, right, is when do you stop investigating and start getting to a determination writing. And again, this is the reason why you want to be mindful of what policy you're looking at and what is the nature of what you're investigating, so that you can be prepared at the very beginning or as early as possible in the process and throughout the process to be asking the questions that are going to get you the information that you need to make a determination on the policy as it stands. One example might be if there's a sex discrimination policy that requires both objective and that the conduct be both objectively and subjectively offensive. If you're only including information about whether the conduct was subjectively offensive, and you don't have information that helps you determine whether it was also objectively offensive, you're going to have a hard time reaching a determination. So being mindful that you have to know that that's part of your policy, that you have to ask questions about that or somehow get that information, and then that you have to identify those facts in the course of your discussion in the report. As you're doing that, always keep the standard of proof in mind, and always, as I said, be sure to address each of the elements of the policy that or policies that are under review. And so here's a very quick sort of look at what a report could look like. Of course, if it's a summary report, each of these sections will be very brief. As if it's a more detailed report, it'll be more fulsome. We talked about quite a number of these already in detail, so I just want to focus on the last couple. Of course, the findings are the key part of why you're engaged in this process, or why you've been engaged in this process. I talked a little bit about recommendations. I put that in brackets because it may not be appropriate for the case. And of course, additional observations to the extent that they may be appropriate, as Darrick mentioned, things like, what are employees that you've talked to suggesting that might be a reasonable outcome of the investigation, or something that may need to change in the department or in the employer that you're working with. So just a couple of final thoughts to try to tie us back to where we were at the start. A reminder again about the importance of keeping privilege in mind as you're creating the report or reporting out in some way, avoiding including privileged information if the report is not going to be privileged, or on the other hand, ensuring, as Rayner suggested, that you have language on the face of the report that confirms that it is privileged. And reminder again that if you're the investigator, you've been engaged to get to a determination if at all possible. And so even if the determination is there was not a policy violation, or maybe it's a he said, she said situation, there may still be some determination that you can reach. With that, we have just a couple of minutes for questions, and we did get quite a few in the chat. Unfortunately, we won't quite be able to get to all of them, but I thought maybe we could reach one or two in the last couple of minutes that we have, and then we'll certainly, as we're doing that, I'm going to share the screen that has our SHRM and HRCI activity codes. So there was one question in here about do you suggest interviewing the respondent? When do you suggest interviewing the respondent relative to the other witnesses? Would you save the respondent for last, meaning the person accused, or interview them before others, or something else? And so I'll give my quick thought, and maybe Darrick or Rayner, if you're comfortable, jump in. I would say the usual, it depends. Often it's helpful to get information and speak to the respondent last, because it's a little bit more efficient that way. You can understand the scope of what you're can ask about at that time, and you can avoid having a second interview. On the other hand, sometimes it makes sense to get to the respondent as quickly as possible, understanding that you may need to speak to them again if you get other information down the line. Darrick, what are your thoughts?
Generally, I agree with that. The general approach is to interview the respondent last. That's especially true when the investigation is going to take place in a short period of time. You don't have concerns about having an opportunity to go back, because if the investigation is going to last 3 days, it makes sense to gather all the information that you can before you talk to the respondent, so that the respondent can address any of the issues that you need addressed by the respondent. And then you will have a chance to circle back if you need to circle back with anyone after that. So that's the general approach, but I agree with you, that can depend on the circumstances as well.
Perfect. And with that, we have reached the top of the hour. For folks who submitted some questions, we'll be reaching back out to you with our thoughts to see if we can help you resolve some of those issues. And in the meantime, we thank you very much for joining us today. We hope you found this helpful and useful, and we look forward to connecting with you in the future. Thanks, everyone.